An amendment was made to CrPC in 2008 and 4 sections were inserted: 41A, 41B, 41C and 41D. Section 41A says that a police officer shall issue a notice directing the person to appear before him whenever arrest is not required. So, in every case where arrest is not required, the police officer shall issue a notice, and when such a notice is issued, it shall be the duty of that person to comply with this notice, and if he fails to comply with it, then the police officer may arrest him. We saw earlier that under section 41(1)(b), arrest will not be required if the police officer is not satisfied that it is necessary. The arrest becomes necessary only when the sub-clauses mentioned there from A to E were invoked. If none of those contingencies arises, then arrest will not be necessary. And in all those cases where arrest is not required, then a notice will be issued. Section 41B prescribes the procedure of arrest. The provisions contained in this section are directly taken from the directions given by the Supreme Court in D.K. Basu's case. This section provides that when he makes an arrest, the police officer shall bear accurate and visible identification of his name. He will also prepare a memo of arrest. This memo of arrest shall be attested by a family member of the arrested person or a respectable member of the locality where the arrest is made. This arrest memo is also countersigned by the person arrested. The police officer shall also inform the arrested person that he has a right to have a relative or a friend informed of his arrest. You will recall that all these three provisions, which are now incorporated in section 41B, form part of the directions given by the Supreme Court in D.K. Basu's case. Next comes section 41C, which provides for establishment of control rooms at the district headquarters as also at the state headquarters. The state government shall establish a police control room in every district and at state level. Names and addresses of persons arrested shall be displayed on a notice board which is kept outside the control room in every district. So at the control room, complete details of all persons who are under arrest in that district will be available. And similarly, at the control room at the state level, which forms a database for information of general public, it will contain information in respect of all persons who have been arrested throughout the state, and it will also have a mention of the nature of the offences alleged to have been committed by these arrested persons. This provision is also directly taken from the directions given by the Supreme Court in D.K. Basu's case. And lastly, section 41D, which is captioned as rights of arrested persons. It says when a person is arrested and interrogated by the police, he shall be entitled, he shall have a right to meet an advocate of his choice during the interrogation, though not throughout interrogation. This provision is also directly taken from the directions in D.K. Basu's case, and this section now gives a right to every arrested person to meet an advocate of his choice during the interrogation process from time to time, though not throughout the interrogation. All these sections were incorporated into the Criminal Procedure Code 1973 by the Criminal Procedure Amendment Act of 2008, and All these provisions came into force from 1st of November 2010.